So welcome to the U.S. Asia Law Institute Speaker Series. I'm Jose Alvarez. And so before we start today's program, I want to say that November 6th, next we have Taiwan Legal, another one of our series on Taiwan and legal issues. And this is about what do trade agreements say about Taiwan, and that it will be at 7:30 to 8:30 p.m. Eastern Time. And it's only on Zoom. So today we welcome Harlan Cohen, who is our own NYU graduate, I'm proud to say, on outward investment restrictions and international laws challenge. Let me just say a few words, although his short bio is there on the website. He is now a professor of law at Fordham Law School. His teaching and research interests focus on international law, international trade, international legal theory, global governance, and U.S. foreign relations law. He's a vice president of the American Society of International Law, has been a member of the board of editors of the Journal of International Economic Law, and he's also of the American Law Institute as well. And previously, he served as on the board of editors of the American Journal of International Law and will soon be, in April, one of the co-editors-in-chief of the American Journal of International Law. So congratulations, Harlan. Prior to joining the faculty at Fordham, he was the Gabriel M. Wilner UGA. I'm not sure what UGA stands for.
University of Georgia.
University of Georgia Foundation Professor in International Law at the University of Georgia Law School and faculty co-director of the Dean Rusk International Law Center. He came to Georgia, as I said, from NYU School of Law, where he was a Furman Fellow. And prior to that, he worked at Cleary, Gottlieb, Stein, and Hamilton, and he served as judicial clerk for Judge Feinberg of the U.S. Court of Appeals for the Second Circuit. He holds an MA in history from Yale University and previously from Yale College, a dual degree in history and international studies. And as is our practice, we've given him only 20 minutes to survey a pretty big article, actually, that's forthcoming in the University of Seattle Law Review on Outward Investment Restrictions and International Laws Challenge is the title of the article as well. So to you.
All right. Thanks so much, Jose. Thank you for into the U.S. Asia Law Institute. It's always a pleasure to be back in the educational environment at NYU that nurtured me as a student and that has continued to nurture me since. I also really am grateful for the opportunity to have a chance to remember Jerry Cohen, who did so much to create these spaces and to foster and inspire these types of conversations. My focus today, as you just mentioned, Jose, is on a very specific, somewhat technical U.S. investment rule. But as I'll discuss, I think it tells us a lot about not only the current relationship between the United States and China, but also our broader, increasingly competitive international order. Now, that specific technical rule is the U.S. Outbound Investment Rule, which was issued in November 2024 and came into effect this past January. It hasn't gotten a ton of attention outside of specialists and law firms, though for reasons I'll mention, it's gotten a lot of attention from law firms. I think that's in part because of a deliberate effort by the government to minimize the importance of the rule and its impact. But I think ignoring it would be a real mistake. Despite its technical look, the adoption of the outbound investment rule was actually a momentous move, one that confirmed a significant shift in U.S. policy towards both the global economy and towards transnational businesses. For one thing, the rule confirmed that what might have been an ambivalent, uncertain trend in U.S. approaches towards China over the past decade was now very much policy. More importantly, the outbound investment rule highlights the extent to which the global economy has itself now become a broader battlefield, and the extent to which international law rules that were meant to encourage economic cooperation really fail to meet that challenge. I'll talk a bit about both, but in highlighting these realities, I think the outbound investment rule also helps clarify and ask before us. And at the end, I'll try to suggest some ways international economic law may need to adapt to maintain peace in a multipolar and competitive world order. So what is the outbound investment rule? The outbound investment rule is often described as a counterpart to more traditional investment screening, a quote-unquote reverse CFIUS. So what is CFIUS? So this is something, Jose, I know that you are an expert on, but for others, for the past few decades, the United States has had an interagency process, the Committee on Foreign Investment in the United States, CFIUS to screen investments from abroad for potential national security threats. Perhaps a company tied to a foreign adversary might be trying to buy a U.S. company with access to sensitive technology or know-how. The committee can consider the potential investment, look at the national security concerns, and if worried, could suggest changes to the deal. You might spin off a division, or you might sell certain IP rights before making the actual deal. In some cases, right, if they couldn't actually assuage those concerns, right, if those kinds of deals weren't available to get rid of the national security issue, CFIUS could actually block a merger entirely. In rare cases, they could actually unwind a deal that had already been done. These are very potent powers. For a long time, though, CFIUS stood more as a fail-safe than anything else. Investigations were quite rare. Blocked mergers were almost infinitesimally so. This started to change with the intensifying economic and geopolitical rivalry between the United States and China. Chinese investment in US companies started to raise concerns among US policymakers, with semiconductors, data, communications really taking center stage. CFIUS's decision to unwind the Beijing on Kunlun Tech's acquisition of Grindr was something of a turning point here, where concerns about data access went from being something that was merely kind of a hypothetical talking point to an actual real world impact. That was followed pretty quickly by the enactment in 2018 of the Foreign Investment Risk Review Modernization Act, FIRMA, which expanded CFIUS's authority. Since then, CFIUS investigations have very much been on the rise. There are a lot more of them, and China is the main target. Now, during the debates over FIRMA, some people raised quite concerns about outbound investment, about US investment in other places. If the concern was Chinese access to advanced technologies and know-how, right, should the US worry about US investors funding and perhaps applying their expertise to the development of these technologies in China itself? Now, this was something of a novel question. Well, obviously, there have been countries, individuals, entities that have been subject to sanctions, right? The policy of the United States has generally been to encourage investment abroad. It's not easy to figure out exactly how to create a kind of reverse CFIUS, trying to create this sort of outbound investment process. So Congress got to work on this, but as they tried to work through possibilities, the executive branch decided to take the initiative from them, perhaps worried about what Congress might come up with. They announced plans, they collected comments, and then last November, they issued this final rule. So what does the rule do? The Outbound Investment Rule creates two categories of investments in semiconductors, microelectronics, quantum information technologies, and artificial intelligence that are subject to regulation. The first category of investments is simply prohibited. Just can't invest in these things. The prohibited category includes the design of the most advanced semiconductors and the means to produce them, as well as quantum information technologies and artificial intelligence that are either designed for military, government intelligence, or mass surveillance end use, or that have been trained using the most advanced computing power, something flop rate. The second category of investments is permitted. It's legal, but it must be reported to the Treasury Department. This reporting category includes the design and production of semiconductors and artificial intelligence systems just below that threshold for prohibition. The prohibition applies to investments made by US persons, which is understood pretty broadly to include also controlled foreign entities, basically any entity whose investment decisions a US person has the ability to direct. And it applies to investments in a person of a country of concern, also broadly defined, to include even foreign entities that are controlled by such a person. The rule is written in a seemingly neutral way. It can apply to any country of concern, but the annex listing the country of concerns only lists China. Violations of the Outbound Investment Rule are subject to criminal and civil penalties under the International Emergency Economic Powers Act, IEPA. US investors are only subject to penalties where they have knowledge of the relevant facts, right? They know who's actually in control. They know what the end use might be. They know what the computing power might be. But knowledge can be inferred where the investor failed to conduct a reasonable and diligent inquiry, right? Essentially, this creates a de facto due diligence requirement. All right, so what should we make of this? For one, it should be clear that the reverse CFIUS nickname is clearly a misnomer, right? This is a very different program. It is not a screening process. Right? It is not a way of winnowing out problematic deals. It's a ban backed by criminal penalties. Right? Enacting it under IEEPA here is something of a tell. Right? IEEPA is the main authority for U.S. sanctions. And putting labels aside, from the standpoint of an American investor, this is a sanctions regime. Beyond that, though, the Outbound Investment Rule reflects two significant changes in U.S. approaches to both China and U.S. businesses. First, the focus on Chinese technological development is clearly no longer about protecting against national security narrowly construed. Right? The focus is as much on technological advancement as it is on potential end uses. It's Chinese advancements in these fields entirely that the U.S. seems to need to stop. Some have already taken this as the message of increasingly strict export controls on semiconductors to China, but this outbound investment rule really confirms that. And it's notable here that those touting the rule have often suggested that their biggest concern here was the ability to get kind of business management know-how from these investors as opposed to funding itself. It also dovetails with former National Security Advisor Jake Sullivan's comments on changes to U.S. policy. Basically, as Sullivan explained, from the U.S.'s perspective, it would not be acceptable for the U.S. to lose its position as technological leader. From the Chinese perspective, this would sound like the U.S. is basically saying that China cannot meet its developmental goals in this particular area. Dual use seems to have taken on a new meaning here. From the U.S. perspective, China cannot become the leader in these technologies, whether it's used for military advantage or for economic advantage. It's not clear that the two can actually be separated. They've essentially become inextricably intertwined. This might be a realistic assessment of both the technology and the state of the relationship. But given prior U.S. efforts to carefully distinguish between national security and economic competitiveness, at least rhetorically, this is a pretty significant shift. And it's one that has been noticed outside the United States, but has not fully been admitted inside. Second, the outbound investment rule represents a much more aggressive, adversarial, distrustful approach to U.S. businesses. CFIUS treated U.S. companies as allies or partners, right? As a relatively limited screening mechanism, it gave U.S. companies a pretty wide berth to run their businesses as they saw fit, asking them only to report deals that might be of potential concern. Even when CFIUS had concerns, it usually sought to work with the company to try to avoid them. The outbound investment rule takes a very different, much more distrustful approach. It essentially commandeers U.S. companies to fulfill U.S. government policies. It's not just that the punishment here is a criminal sanction, but the whole scheme seems designed to chill investment. Essentially, you're trying to get private investments to serve your goals. Between the sanctions, the due diligence requirement, the difficulty monitoring flop rates, uncertainty about the meaning of different kinds of ownership rules and end use makes the decision for a company thinking about investing pretty easy, right? It makes it much easier for them to simply say, we're going to draw a big fence around this entire area of investment and avoid it entirely. In a sense, this scheme is even more challenging and chilling than traditional sanctions regimes because there's no list of prohibited entities that you could code into your compliance system. Everything requires investigation and judgment calls. Not investing in China is a much cheaper and safer route. And for whatever it's worth, the evidence so far suggests that this has been the effect, right? So as I mentioned before, right, the second category covered by the outbound investment rule covers investments that are permitted, that are legal, but must be reported. Those reports have been dwindling considerably, suggesting that investors are staying away from even the areas that are actually still permissible. But even to the extent to which the rule doesn't chill, right, it turns these companies into potential agents of the United States, using those companies' due diligence as a source of intelligence on Chinese advancements. Right? Under the outbound investment rule, essentially U.S. companies become a tool, an extension, a weapon of the U.S. government. But more broadly, I think this is a story about more than just the United States and China. The rule represents a shift in the global economy and the insufficiency of current international law rules to deal with. Around the world, economic security strategies are proliferating. Whether we call them sanctions or something else, tariffs and trade restrictions are being wielded as foreign policy tools by the United States, by China, by Europe, by Russia, Japan, India, Saudi Arabia. We could keep going on. States look for strategic economic choke points, critical mineral supply chains, the dollar clearing system, sea lanes that they can or cannot control. And in response to a growing sense of insecurity, right, states are throwing up defenses, right? Here we might think of export controls, investment screens, or fortifying their economies with strategic investments. And subsidies, you might think of things here like the Chips and Science Act in the United States. These trends have only accelerated over the 9 months since this rule was put into force. It's not just the United States, it's a global reality. In an increasingly multipolar world, right, national security and economic competition are increasingly intertwined. Right? Winning the race to control key technologies of the future seems key to both military and economic power. It's not clear that the two can be disentangled. International law rules that were built for a different era on win-win premises meant to manage disagreements and cheating at the margins are straining to handle a zero-sum world where everyone is worried about who controls what trade flows, who controls what critical minerals, who controls what components and technology, even who controls what territory. And in the face of this kind of competitive thinking, existing rules provide very few constraints. Right? So we might have once hoped to look to WTO with extensive agreements, 166 members. We might have thought that WTO might be able to manage these issues, but it's been mostly sidelined for these security fights. Its once idolized dispute settlement system essentially disempowered by the US elimination of the appellate body. Investment is governed by a web of bilateral and regional agreements, which might provide some constraints, but national security is often carved out of these agreements, and it's unclear to what extent these agreements actually apply to investment screening at all. Advocates have long strained to try to discipline sanctions, some impact, but if we look around the world, what we're seeing is that sanctions only seem to be on the rise. But the outbound investment rule really makes the lack of rules in these areas stark. Right? Restrictions on outbound investment appear to be totally unbound. This might have been okay in another era, but for decades, states have been encouraged to globalize, to open their doors to foreign investment, to rely on access to global capital. Removing that access now is an aggressive act, right? It can threaten a country's development strategy, it can threaten its economy, it can threaten its political stability. But here, the international law rule remains the same, that no state has any obvious obligation to allow its citizens to invest in any other. To put this another way, policies that could create massive tensions between states face no real legal guardrails. In a world in which access to capital and markets and technology can be weaponized, international law provides no means to protect peace. So where do we go from here? One possibility is reflected in the European anti-coercion instrument, and that possibility is the idea of reinvigorating some international law prohibition on economic coercion. Recognizing that economic tools are increasingly being weaponized for political purposes, the anti-coercion instrument argues that some economic measures can violate international law's prohibition on intervention. Perhaps tellingly, the anti-coercion instrument was inspired by US actions under the first Trump administration. It was drafted specifically with China in mind, and it's most likely to be used against the United States. But the real value of the anti-coercion instrument is less in what it does or doesn't do, but in how it articulates what might actually be concerning about these economic measures beyond any particular international economic law agreement, right? It gives us a way to explain why we think these measures might be problematic. It gives us a way to talk through our concerns. It articulates the threat of unrestrained economic warfare and provides a frame that can start to anchor diplomacy, right? I don't have huge hope that we're going to come to some agreement about what counts as economic coercion, but this at least gives us a way to actually start talking about what the concerns might be. But what I think is really needed here are rules for economic statecraft, rules that can manage conflict, that can set expectations, that can ground diplomacy. If geoeconomic competition is the new reality, right, states are going to need ground rules to make sure that it doesn't get out of hand, that it doesn't spiral out of control. Right? Here we can imagine developing best practices for the use of economic security tools. Right? These don't have to necessarily take hard law form. To be very difficult to get to right now. What we need now instead are expectations, best practices that can ground practice and diplomacy. You might think here, for example, of expectations about notice and justification. Right? If you're going to enact one of these measures, you need to provide notice where possible, and you need to explain what your target is and why you're targeting it. This might include expectations with regard to proportionality, right? That the measures be proportionate to your goals and that you minimize unnecessary harms either to your target or to innocent third parties. This might include expectations of process, processes in adopting, reviewing, or revising these measures that other states know are there and can intervene in. We might also encourage negotiations over protected targets like food, potential agreements on compensation. Most of all, what we need here, what states need, are fora. Right? They need fora for thinking, for talking, for debating, for arguing, fora where they can share their intentions, where they can make complaints, where they can talk through alternatives, where they can express their anger. Right? The goal are not so much rules that warrant or forbid certain actions, but instead rules that can manage the inevitable invocations of security, that can improve communications, that can clarify intentions, and most of all, avoid unnecessary escalation. In this sense, taken seriously for what it is, I would argue that the Outbound Investment Rule, by revealing current international law's gaps, can actually point the way towards a different international law for a more competitive world. Now, one last note. Last January, when this rule came into force, feels like a long time ago. Certainly does to me. And this rule already might seem like an artifact from a distant civilization. Even as China has announced its own ban on chips from US-based NVIDIA, it's unclear where the outbound investment rule fits in the more flexible deal-making world of Trump 2.0, in which chip makers like NVIDIA and AMD can apparently pay for access to the Chinese market. I'll be curious to hear if other people have thoughts on this. But I would suggest that the rule actually provides a link between Biden and Trump foreign policy, evidence that the world of geoeconomic competition is not something specific to Trump, but a much longer worldwide trend. And the second Trump administration, by fully tossing off the cloak, right, by revealing that the goal is totally just a matter of geopolitical and economic competition and treating all of these tools, tariffs, export control, subsidies, sanctions, interchangeably, right, only accentuates the need for rules that can help distinguish between the acceptable and the unacceptable, right? Form is not going to be the thing that does this anymore. We're going to need to create something different. Whether or not the United States will follow these kinds of rules, others will need them amongst themselves, lest everything spiral apart. So I'll stop here, hopefully on this potentially more positive note about moving forward.
Well, it was
thank you.
Heavily concealed amid quite disastrous notes, but never mind. So I guess one question would be, you've made a lot out of what some people would see a narrow rule,
Yes.
right? That really what we're worried about, you can see it in a technological sense, AI and semiconductors, or you can see it as this is all about China. So what do you say to people that really you've turned a small technical rule into a major law review article on the world order and how really the whole regime of free trade and investment flows is collapsing in front of us? And we know that from other things, but what do you say about that?
Yeah, I think there's some kind of metaphor here about elephants and mouse holes.
Right.
I think that's a fair question to ask. Why is this the thing to focus on as opposed to something else? And why would this be a kind of a turning? So I think there's two things to this. So one, I don't think that the outbound investment rule is creating a new scenario or a new reality. It's recognizing it. Right? It's reflecting it. Right? It's basically a way to kind of see where things actually are. So to the extent to which we had been watching certain trends, think here about kind of the export controls on semiconductors running up into this, or think about the general competitiveness of the global economic order. Right? We might have been trying to figure out exactly what this means. I think this particular rule, this particular outcome starts to tell us a little bit about how we should have been reading all of those before. But beyond that, I think the rule itself is somewhat telling. Right. So this rule is different than more traditional rules here because it's so clear, right, that it's not acting simply as a defensive measure with regard to national security. Right. It's very easy to look at CFIUS and say, okay, this is something reasonable that's here just to guarantee, as a fail-safe, that things that are a real risk to national security don't get through. This is very different, right? This is not looking for national security risks. It's defining the national security risk, and it's defining the national security risk as the technological advancement of China, right? As the technological advancement of an adversary, right? That is the defined national security risk here, and it is targeting that, right? So it's not saying, all right, we need to be careful now in looking at this. It's saying we're going to try to make sure that that doesn't happen, right? We are going. As I said, it dovetails with the speech by Jake Sullivan by suggesting that this is the tool to make sure, right, that we keep China behind us in technological advancement. I think that's very different from where we were before, or at least it's much more open about where we are.
And it's fascinating that that comes from Sullivan under the Biden administration, right? We're used to interpreting the intensity of competition with China under Trump 1 and now Trump 2. But here, if the key is, and I think you're right, that we're redefining national security as it's us as the winner versus you.
Right.
And that, I think you're saying, carries out beyond AI and semiconductors.
Right. I think that's AI and semiconductors is now kind of the leading edge of technology that we're talking about, but it's not about AI and semiconductors. It's about being the most powerful economically and militarily in the world, right? And so the question is, what things will lead you to that? The concern right here is about these advanced technologies, but it could be other things as well, including access to minerals, including access to sea lanes. Think here about the language with regard to the Panama Canal and Greenland. All of these things are really just tools to achieve the overall goal, which is to make sure that the United States remains in sort of a certain place within the global pecking order. But I think more broadly, it also redefines how we think about all these other actions being taken by other states, right? So the US might be perhaps most open among some states in doing this, but I think what we're seeing is that all of these actions taken by these different states are somewhat in this valence, right? All of these states are worrying about where they will be in a global pecking order, and are taking actions meant to either fortify their current position or to guarantee that they are in a position to take the lead later on.
And at the same time, by defining national security this way, it is clearly an affront to China's view of, hey, we have the right to also engage in trade and investment. We have the right to develop ourselves. So the escalation from a trade dispute to something far greater is far higher under this view.
Exactly, right. So by mixing economic policy, economic competitiveness, and national security, by making them so closely intertwined, right, you make any economic action you take, right, potentially a national security concern for your adversary. Mm-hmm. Right. So here, this is why we might need these kinds of best practices. We're really going to have to worry about signaling in this new world. Right? How seriously should China take this particular measure? We're going to really have to think about how we guarantee that you don't have things spiraling out of control, that things don't regularly escalate beyond kind of the area where they're in. And that's going to be very hard.
Well, and when you started talking about the alternative scenario where you have dialogue and you have various ways to get states to consult with each other as to definitions for national security and what truly should be worried about, many people had seen that going on under the WTO because most of the action, according to trade specialists, was precisely in the committees, yes, where before anybody took anything to a dispute settlement, there was that. Isn't that still going on?
So it is to a certain extent. There's some action at the WTO and committees on national security issues. It'll come up kind of in a sideways way in other committees. There isn't a national security committee, and there have been some, like Simon Lester, who suggested there should be a national security committee, which would be potentially a good idea if people are willing to do it there. It's happening also outside the WTO in various regional, bilateral, ad hoc arrangements, right? So you can see the demand for these kinds of rules in things like the US-EU Trade and Technology Council, where there's an attempt to try to figure out, okay, how do we come up with some ground rules for what we're doing here? Because many of the things the US is doing with, say, investments in chips pissed off the Europeans, right? So there's a sense here we need some ground rules on how to do this. Also, some of the rules with regard to export controls and their effect on Dutch-based ASML, right, the producer of these machines that make the semiconductors, right? These were creating tensions too. So there's a sense there that there was a need for kind of some ground rules. You also see this a little bit in work within the Quad. You see this in some work to some extent with the Indo-Pacific Economic Forum, right? There's some sense that there is a place for this, but we need to figure out ways to make that happen both more rapidly and more multilaterally if we want to make sure that there is kind of a signaling we need in order to guarantee it.
So I guess maybe you want to say a bit more about the European reaction to this, mm-hmm, because when you described it, where the U.S. Companies are responsible for what their foreign entities do, that sounds very much about our old problems with extraterritorial application of our sanctions, which led to countermeasures and so forth in Europe. You also mentioned the anti-coercion instrument. Do you want to say a bit more about what is the likely European reaction? Will they adopt their own constraints on AI and semiconductors vis-a-vis China, or will they actually say you're going too far?
Both, right? So I think they are going to say you're going too far. I think they are as worried about competition with the US as they are worried about China in many ways, right? I think that depending on the day of the week, who they're fortifying themselves economically against may change.
Mhm.
So they're going to complain about what the US is doing, and they do see what the US is doing in many of these realms as being aggressive. On this particular issue, they may actually be in line with the US, right? So Europe is considering its own outbound investment restrictions on China. And I think that if anything, they will take the fact that the US has taken the first step here as a sort of as permission for themselves to do the same, right? They may or may not do it, but I think that it's much more likely now after the US has done it than it might have been before.
And this is really about development of AI. This is not a competition over how to regulate AI. That we or at least the Europeans are worried about privacy issues, whereas that's not the concern under presumably Trump, right? This is about technologies. This is not about how you regulate AI, right?
Yeah, I think this is actually undercutting other concerns about regulating AI, right? So particularly in Europe, right, there are those who would want that to be the focus, right? Thinking about things like ethical AI, right? But to the extent to which you see things like the Draghi report suggesting that all of these kinds of regulations are dragging Europe back in these various races, right? It seems like the reaction is, okay, we better get rid of some of those regulations, soften some of those regulations so that we can continue to be in this fight. I mean, it seems like right now, if anything, at least in the European Commission, right, the zeitgeist is one where we need to figure out a way to kind of ramp up our competition in all of this, right? It can't be the US versus China. We need a place in this competition too. And so that's actually pushing aside, right, more concerns about things like regulating AI, right? It is sort of an attempt to kind of try to race for the technology itself.
Do we have a sense of other allies' reactions, Japan or others on this issue?
So I think the reactions are, so it's mixed, right? So I think that with regard to China specifically, some of these allies may be in a similar position, also worried about Chinese areas. So in some sense, they're on the same side of the competition. But I think that they also all individually are in this race, right? None of them want to fall behind. So they're all thinking about sort of how they maintain their strategic position. This is sort of the danger of the current situation, right? It's not one where people think they can kind of rest on kind of the cooperative arrangements that we have to kind of move forward in kind of a natural way. There's a sense of anxiety, right? That the global pecking order is shifting and that if people don't take the right move, they may fall behind, and they maybe fall behind in ways that are not just economic, but that are security ones as well.
Well, so I guess as a devil's advocate, so what's wrong with that concern, right? I mean, is your worry that the lack of rules would lead to serious breaches of the peace or other violations of the law? Or are you saying that there's something intrinsically wrong about each country trying to achieve the best on these two?
I mean, I might have my own views on what states should or shouldn't think national security concerns, but I don't think that's the way we should be thinking about this, right? States are going to define their own sense of national security. Peoples and states are going to decide what makes them feel secure and secure, right? They have their anxieties, they're real. And they may be based on very real concerns. The question is, do the tools we have right now react responsibly to those kinds of concerns? And what the worry is exactly what you said at the beginning, that with everyone competing against one another without any kind of guardrails, you do run the risk of serious escalation. Right? One way to think about this, right, is that having a pretty clear, relatively robust rule set creates actually mechanisms for sending pretty refined signals, right? Because you might be following 5 rules while violating 1. You can make it pretty clear what things you care about and which ones you don't. In the absence of those kinds of rules, which is where we've kind of been left in the economic national security space, right? There's very, very few rules that actually cover these things. It's very hard to send clear signals about your intentions, which makes everything that states do creates much more potential for escalation, much more potential for miscommunication, much more potential for overreaction. And I think that to the extent to which we want to keep the peace, right? We don't want unnecessary conflagration, right? We need kind of some way to get states to be able to kind of signal to each other much more clearly.
And U.S. business seems to be comfortably rolling along here on this rule, as you described it, by saying, "Look, it looks like between the reporting and the prohibited, the best way forward is simply to chill out, literally, by not having the investment." So I guess U.S. industry is not a pushback here.
I mean, there was pushback. So this is actually one of the good things about the way the rule was done. So in some ways, you could actually look at the rule, right, as a model for how to do this. Right? Even as the rule represents kind of the concerns about where we might be going, the rule might actually be a pretty good model on how to do this, right? This was done through notice and comment rulemaking, even though it's not entirely clear you have to.
So this is not a unilateral White House executive order, like Norway.
Right, exactly. So we think about IEPA orders, right? IEPA orders do not normally have notice and comment. It's not clear you had to do this, but they did do that. They took comments from industry. They used that to some extent to try to refine some of the rules about kind of what kinds of investments would be covered, what kinds of end use should be covered, how they should define certain kinds of ownership, right? So they did use it that way. But once the rule is in effect, it seems like no one really is that interested say about this. They're very happy. The impression I get is everyone is very happy if industry simply decides to draw a large fence around all this, right?
So at this point, I'd love to open it up for folks here in the room as well as those outside. So welcome. And if I don't see any questions, we'll proceed with the conversation. But I encourage rules. So yes, there's some coming.
There's a question, coming from online. The reference you made to the steady dwindling in the number of companies that are reporting to Treasury that they are making these, I guess, close to forbidden but not forbidden investments. Is there any indication that these companies are alternatively investing in the U.S.?
I have not seen any indication
that has been research.
Right. I don't know how to do the research. I mean, this is something where it's not been that long, right? It's only been 9 months. This is a case where you actually can see something, which is the reports to Treasury under the Outbound Investment Rule. Beyond that, it's hard to know exactly what's happening. But it'd be a really interesting question to study.
And that's not the conscious intent, right? It wasn't billed as this is putting us back and putting Americans to work like some of the other Biden initiatives, right? This was actually protect us from China advance.
Right. I mean, it was meant to work together with other things the Biden administration is doing to try to encourage investment in the United States, particularly in some of these areas, right? So the CHIPS and Science Act does try to encourage investment in those areas. And you could see the two as working together because to the extent to which you have investors who want to invest in AI or in semiconductors, maybe they now will look to the US or to its allies. But it's not clear whether it's having that effect or not. I don't know.
I ask a follow-up on
Sure.
On behalf of the person who asked the question. Is the information, if we go to the Treasury website, can we see who has made these? Are these reports themselves actually fully available, or is it just a number that you can?
Actually, I'm not sure.
Okay.
I've only seen kind of the reporting on it.
Thinking about how we can do the follow-up.
It's a very interesting set of questions.
Bruce?
So I'm still curious about the kind of extraterritorial application of outbound investment restrictions. And particularly, I'm thinking of Japan and Korea, who probably think that trade and investment with China is more important to them than we think is more important to ourselves in the US. Despite the fact that it's no longer going up, it's probably leveling off to going down somewhat. So nevertheless, what are the direct applications or expectations about Japanese or Korean companies more or less following what the US program is, and how would that work through threats on tariffs or?
So, I mean, the interesting thing here is this is where framing this as a sanction has the real impact. Because this is framed essentially, I mean, it's not called a sanction, but it works like a sanction. Essentially, there are criminal penalties on the US person, right? So so here we have to be thinking about kind of the specific rules, and they are very hard to parse. But essentially, if a US person has the ability to direct kind of the investments of a Japanese or South Korean company, right, they will fall under these rules. But it's that person who's the one who's going to be subject to the penalties. So in a sense, it doesn't really matter they're upset about this. It doesn't really matter whether the Japanese company or the South Korean company wants to engage in this investment. That U.S. person is now subject to criminal penalties and is not going to want to be anywhere near that. They're going to want to either find a way to protect themselves against it, or they're going to want to stop it from happening. There is an interesting kind of dovetailing here, though, with the fact that Taiwan already has outbound investment restrictions on many of these areas. So in some ways, it does connect with that.
Well, I also think it's interesting because the typical case with Japan or Korea would not be that a U.S. person controls the entity, but it's a subsidiary of the Japanese or Korean entity. So are we going to get like Foreign Corrupt Practices Act? The fact that you have a subsidiary in the U.S. is going to expose you to much broader U.S. regulation than you might have thought.
I mean, on this,
That would be a very aggressive interpretation, but I'm just wondering, to what extent the U.S. is maybe inclined in that kind of direction.
Yeah, I mean, we'll have to see what the prosecutions actually look like. There are some people know of this is like the CFIUS community, right? There is a bar of these things. It has some sense of kind of what's going on, but it's not public for the most part. So we have some sense from the usual sort of CFIUS export control and investment screening bar, right, that there are prosecutions in play, but we don't yet know the details really of who is being prosecuted. So we'll have to learn a lot from that. Right now, this is kind of weird regulation by FAQ, right? Where, like the Treasury puts out kind of like, who is covered by this, but it always raises more questions. Which is why, going back to what I said before, law firms love this, right? Because they're putting out notices regularly of like, this is what to make of the latest FAQ on this. But it's very hard to figure out right now exactly who the U.S. government plans to target. But going back to something, Jose, you were asking about before, is quite open-ended, right? The U.S. government could decide to do all sorts of things, either under the current version of the rule or by expanding the rule, right? They can, right now, the only country in the annex is China.
But it could be Venezuela.
It could be anyone they want to put in the annex.
So it sounds like you'll have to write another follow-up article next year.
So some people would say that this basically emulates the restrictions on outward bound investment that China has had for the years, right? And that would echo some of the other things you're saying, that some of the things we're doing, commandeering, private market, whether it's through partial ownership of TikTok or other things, are actually emulating what we associated with China's more state-run form of capitalism. Do you have anything to say about that broader picture? Are we starting to emulate China in way of competing with them?
So it's an interesting question. I don't know to what extent we're actually emulating, in the sense that we are actually taking a lesson from China and applying it. Right? Rhetorically, we're certainly using that as a justification. Right? So there are definitely U.S. policymakers who will say, right, we're simply doing what China has done this whole time, or we're getting smart and doing the things that China has done.
They've been cheating on state entities.
Exactly.
They might turn them into state entities.
They might use it as a justification. I don't know that it's necessarily based on a true kind of emulation. I do think it reflects the extent to which this kind of much more competitive order is taking hold, right? So it is not at all strange, in a sense, right, that countries trying to move up the developmental ladder will try to take some of the reins of the economy to try to move it in the direction that's pretty typical around the world. It feels different when the most powerful economic players decide to do that, and shows the kind of anxiety that is flowing throughout the system, right? Where there's a sense that everyone needs to take much more command of their economies, needs to think more about industrial policy, needs to think more about where investments are being directed. You see this in the European Commission too, right? The European Commission very much is thinking about these kinds of things in a slightly different way. And so I think that in a sense that they're kind of, that may be a certain kind of emulation itself. I think there's a difference in the sense that, right, and this is very hard, it's very hard to draw lines between these things. But there's a difference between using industrial policy as economic policy and in using industrial policy as national security policy. And it seems like we may have slightly tipped over that.
Well, some people would have said that you saw a bit of that with the CFIUS over time, that after 9/11, almost everything became a national security issue. Before 9/11, people didn't think of blueprints for a high skyscraper in Manhattan as a national security issue, who sees them and their vulnerabilities. After 9/11, infrastructure, lots of things came in. So I guess there's a possibility that this in turn could politicize or redefine national security for CFIUS purposes. Do you see that feedback?
So it's always hard to figure out exactly what's going on inside of CFIUS, but it seems like that has kind of been a little bit where CFIUS has been this entire time. Right? So the issue here, I think there's a slight distinction we need to be making, right? So there are ways in which economic matters can be national security threats because they allow for military or surveillance or intelligence use. That's one kind of category. So there you're kind of thinking about the blueprints being used for some other purpose. It's a different thing to say that the economic matter is itself a national security concern. And I think that's kind of where this takes us. I think CFIUS has already been there to a certain extent, right? That it's already seen competitiveness as a national security concern.
And if you think of AI as comparable to a particular chip that you need for a weapon system, then you're getting closer to military uses based on the technology itself.
Right. I mean, the problem with AI is it's so speculative as how it might be used, right? That's part of the nature of AI, right? And same thing with quantum. Quantum is even worse, right? People are imagining what uses it might have. It's very hard to distinguish at this point between what might be traditional military concerns and what might be economic competitive concerns. There's so much kind of out there that basically at this point, you're basically saying having these things alone is a problem because we're not really sure what might come from it.
Now, in terms of your solution, you were talking about different proposals of how governments talk, and then you tossed out regional versus multilateral. In the world we're in, isn't it going to have to be at the regional? In other words, multilateral solutions in the classic UN sense of everybody at the table on this stuff seems completely unrealistic.
I think what you're going to get here, the best case scenario here is layering, right? Where what you're getting is not one thing or another thing, but you're getting sort of action in different places that is pushing action in others.
No single WTO for AI.
Right. But when you get it, well, perhaps, but it would be very thin. Right. So the best case scenario, what I would imagine would be you would get lots of smaller kinds of agreements inspiring other overlapping smaller agreements, potentially regional agreements that themselves can create kind of a basis for some kind of thin agreement. But again, the agreement isn't really the issue, right? So it's not really about getting everybody to come to the table and say, okay, this is what we agree on. It's about creating expectations. And you can do that without any formal agreement at all, right? If all of these little bilateral ad hoc regional agreements come to similar conclusions about best practices, those will be the best practices, right? Those will set the expectations for everyone.
Interesting. Questions from the room? Others online?
Yeah. Just wondering, like the flip side to this, are there any voices supporting the other side of the equation, which is the US got to where it is through a nuanced, more open approach, creating dependency technologically to a world where we're forcing competition to create their own technology. And even in the context of military and security, I don't see it personally as an advantage when someone is developing a technology that's a black box to you, as opposed to using technology that you created. So I'm kind of surprised that there is no voice to this. This is being done on the pretext of national security and protecting U.S. interests, but U.S. got to become powerful in the first place through an open approach and creating dependency. So I'm not sure if you have any thoughts on that.
Yeah, I mean, it's pretty telling that that's where the conversation has got, right? There are a lot of people still making those arguments, but they seem to have lost control of the policy levers, right? That they seem to be on the outs within kind of the DC establishment. They seem to, again, you see this playing out in the European Commission too, right? It seems like the forces for kind of making sure that we are competitive, right, have been able to kind of take control of kind of policy right now. And that seems to be where things are, right? That regardless of how things regardless of how we got here before, there's a sense that the times have changed and that there needs to be a different approach. I'm not suggesting we shouldn't keep pushing back on that, but there needs to be some recognition that seems to be where the policy debate has gone, right? So that we can't just kind of rest on, we have a cooperative system that we should rely on. We're going to have to deal with the fact that people seem to be in a different place.
You have a hand up? Yes.
Yeah. So do you think it's fair to say that the rule does not test the boundaries of IEEPA in the same way or to the same extent as IEEPA-based tariffs do, for example? And do you see any implications from the ongoing litigation regarding the matter?
Yeah. So first off, I have problems with IEEPA as a whole, right? So, but that's I tell people like years ago, each foreign relations law, I would say like IEEPA, that's the thing you should be worrying about. The students will look at what's out of my mind, like what's IEEPA? So I have issues with IEEPA generally. I think that there are definite problems with the way in which it delegates authority. I think there's we should have some concerns about kind of the openness of national emergency declarations and what that includes. I don't think that this is quite like the tariff litigation, right? So in two different ways, right? So maybe more than two different ways, but at least two different ways, right? So one, this comes much closer to the core of the kinds of powers within IEEPA, right? As I said, it looks like a sanction. Sanctions are kind of the bread and butter of IEEPA. So in that sense, it doesn't really kind of put pressure on that. It also doesn't necessarily put pressure. And so the example, to put it on the other side here, there's a big question as to whether or not tariffs are meant to be covered by IEEPA. More importantly, they never have been covered by IEEPA. No administration has ever claimed to do tariffs under IEEPA. People talk about what was done under the Trading with Enemies Act before that once, right? But it's never been done under IEEPA. So there's a real challenge there to whether or not the mechanism falls under IEEPA. But beyond that, in terms of the national emergency declaration that's part of this, right? So declaring what the emergency is that IEEPA responds to, there is so much on the books already in the US talking about these particular technologies as national security threats that it really just fits into kind of that very snugly. It's not like the question about, so in the IEEPA litigation, there's a real question of whether or not a persistent trade imbalance can be a national emergency. That's very different from the situation here where you have something that fits very clearly within what's already been thought of as a national emergency, for better or for worse, right? Going back to the prior question. Yeah.
Oh, thank you very much. I have somewhat of a broader question in a way. So it was very interesting. I'm not following this debate at all, so I learned a lot. I thought it's quite interesting how a lot of this can be described as coercion. And my question is, can it be described as an use of force? And the reason why I'm asking is because every couple of decades, global South states and some scholars have tried to broaden this notion of an economic aggression, economic use of force. And I wonder how this kind of development fits in that picture. And if you think that's a notion we should try to go back to in these days.
Yeah, so this is actually the subject of another paper of mine that I could have presented in the Michigan Journal of International Law. And I have been trying to grapple with what does it mean that we have these kind of changing definitions and looking back at kind of the pushes by developing states in the 40s, 50s, and 60s on this, how those kinds of interpretations fell away and how something like the anti-coercion instrument seems to actually be trying to revive them, ironically or not. I do think we need to figure out a way to talk about economic force in international. Right? We have a lot of economic statecraft floating around. Right? States are using these tools in more and more aggressive ways. We're going to have to find some kind of language to talk about this in. Coercion might be the language for talking about that, but we're going to have to figure out a way to in some ways, disintegrate kind of this artificial line between military force and economic force. It's already been happening a little bit in the cyber context, right? Where people are starting to think, okay, these lines don't totally make sense. We're going to need to kind of move to this economic sphere and start thinking, okay, what rules really do apply to economic tools used in coercive type ways?
Yeah, thank you. This is really fascinating. So I guess I have two questions, and maybe I missed something in the discussion. One is about the economic actors' role in these policies. So one way of reading these policies is that they are national security policies that are informed and shaped by national security interests, but they could also be conceived the other way around as ones that some economic actors have an interest in, and therefore are now they want them to be framed as such, and that's just another, because it seems a bit strange to think that. So from a realistic point of view, this would be quite a good reading of different states having their kind of cohesive national security interests. But given the potential discrepancy between, say, some of the leadership and what would be a national interest in some states. So it's not really clear that the government or the kind of executive, say in the United States context, is as concerned about a kind of public interest writ large, but may be interested in a narrower set of interests. So maybe this is just framed as such. And if so, who are the actors who are pushing for this? Or is it some kind of a coalition between certain kind of ideology that has a different view of trade or a different view of the role of all national security and the role of the US, that kind of, and the coalition between that group and some kind of economic interests that or actors that are kind of behind this? That would be kind of one question that I have. And the second is about kind of the flip side. So we're looking at the use of economic sanctions for national security, but we also saw in the Russia-Ukraine front the use of how economic actors are now getting involved in kind of the sanction regimes, and now they're pulling their kind of businesses from Russia as a kind of attempt. So we see businesses engaging directly in kind of warfare through both economic and other measures. So maybe the kind of the borderlines is kind of are fused on that end as well.
So just to take the second part first, I think part of what we're seeing is for a while there might have been some competition in the state and these various different business actors for control for a long time, right? In some ways, we might have said that these business actors were winning, right? These global supply chains look the way they do because they maximize profits for those companies, not for any particular state. I think that rather than this being driven by those interests, this is the state taking back control. Right. This is the state saying, no, we want to control where these supply chains go. We want to control who has access to these various different resources. Right. It's actually a tug of war between the state.
But who's the state? Like, who within the kind of what's the state here? Like, who is doing this? Who is pushing? Who is pushing the ones who are pushing?
Yeah. Well, so there's two things there. So I think there is sort of a foreign policy establishment, right? In the United States, there is kind of the blob, right? I think those are made up of people. I'm not suggesting that that's like an abstract entity. I think it's those people who want control, right? It's policymakers in certain areas of government who want to retake control. So I think that's definitely part of what's going on, though that has created some competition where other parts of the government that might have taken a different view want in on this too, because they know that that's now where power lies, right? There really isn't, going back to the prior question, there's not a lot of, you don't get a lot of power in the government right now arguing for free trade and open markets, right? So everyone wants in on this game. But in terms of kind of the business side of this, which I think is really interesting, it's kind of a little bit hard to figure out exactly how that's playing out here. You could say that this was about the difference between the investors, right, and the companies that are actually engaged in perhaps producing various things, but that doesn't work here because so many of those companies have global supply chains that are going to be affected by these various kinds of rules. So it's very hard to say that it's the investors versus them. There might be some interests who want to kind of foster investment in the United States or in other allies, but it's not clear that they're the main economic actors here. It seems like the main economic actors here have kind of taken a position that they need to kind of roll with it. Right, that there are going to be these changes in the regulations, there's going to be changes in what they can do, and they just have to be as nimble as possible in sort of managing them, whether that means shifting your supply chain to a different country, whether it means finding different investors, whether it means taking advantage of subsidies to build things in the United States, right? It seems like at this particular moment, they're kind of on the back foot. And so going back to kind of your kind of more say Bordusian kind of analysis of this, or we're trying to think about the interest groups. I don't think it's so much about different business interest groups that are doing this. I think this is now about thinking about certain kinds of foreign policy elites and business interests who are actually now locked in some competition.
So we're at the end. Do you want to say anything by way of conclusion at all, or?
So I guess first I'll just say, I appreciate everyone pushing back on this reality because I hope it's not. It's true, right? I hope that we're in a better place in this. But most of all, I just really appreciate everyone's engagement beyond this and look forward for future conversations.
Well, thank you very much for coming.
Thank you.